Hello and welcome to Courts Today by LiveLaw. Let us get to today's top legal headlines. The Supreme Court today heard a batch of petitions challenging the constitutionality of the Waqf Amendment Act 2025. The Apex Court has observed that Urdu and Hindi are one language according to scholars, and language should not become a cause for division. The Supreme Court has asked Maharashtra police to vacate Bombay flats held since 1940s illegally. UP State Commission has held that WhatsApp provides services in India to its users, and so consumer complaint is maintainable against it. In the Kerala RSS members' murder case, the Supreme Court has asked the National Investigation Agency to approach Special Court or the High Court for cancellation of PFI members' bail. And the Karnataka High Court has told the state government to identify and act immediately against clinics run by fake doctors hoodwinking innocent people. I am Urvashi Chauhan with your daily roundup of legal updates from across the country. For detailed reading, you can always visit www.livelawmedia.in. Please make sure to watch this video till the end and don't forget to like, share and subscribe to our channel. Well, before I get to the details, here is an exciting opportunity for judiciary aspirants. LiveLaw Academy, LiveLaw's judiciary coaching initiative, has opened registrations for its May batch. Choose from two tailored courses, that is JESSUP 2.0, a comprehensive 18-month online program covering everything you need to crack the judiciary exam, taught by an expert panel including retired judges, and JESSUP Lite, a flexible weekday-only program for those who prefer a structured yet lighter approach. Sign up today to avail 25% early bird discount, plus enjoy free LiveLaw subscription, case compilations, and much more. Don't miss this opportunity and enroll today at www.livelawacademy.in. Starting with the most important update for today. The Supreme Court today heard a batch of petitions challenging the constitutionality of the Waqf Amendment Act 2025. Over 70 petitions were listed before the bench, comprising Chief Justice of India Sanjeev Khanna, Justice Sanjay Kumar and Justice K.V. Vishwanathan. AIMIM MP Asauddin Owaisi, Congress MP Mohammad Javed, RJD MP Manoj Kumar Jha, TMC MP Mawa Moitra, All India Muslim Personal Law Board, Jamaat Ulema-e-Hind, etc. are some of the petitioners. The states of Rajasthan, Gujarat, Haryana, Maharashtra, Assam, Uttarakhand and Chhattisgarh have filed intervention applications supporting the act. The central government has also filed a caveat. Senior advocate Kapil Sibal started the arguments for the petitioner's side. He opposed the requirement that a person must show 5 years of practicing Islam to create a waqf. He argued this violates religious freedoms. If someone is born Muslim, why must they prove their faith? He contended that the words "in accordance with law" cannot override personal law. He challenged the proviso that waqf by user remains valid only if there is no dispute or government claim. Sibal argued that this undermines waqf created through traditional use, which is central to Islamic practice. Objecting to the clause that waqf cannot override inheritance rights of women, Sibal said inheritance in Islam occurs only after death and that the state has no authority to interfere before that. The CJI here responded, saying that Parliament has passed laws affecting all communities under its powers. Sibal further criticized provisions allowing the government to declare property as its own without a time limit, calling it unconstitutional. He added that appointing a government officer to make such determinations violates neutrality. Sibal also objected to the rule that a waqf declaration is void if the land is later declared a protected monument. The CJI clarified that existing waqf status would remain unaffected unless the monument status came first. Sibal argued that waqf by user, a practice where personal property used for religious purposes becomes waqf, has been unjustly abolished. Requiring registration, he said, interferes with religious tradition, especially when old waqf may not have formal deeds. He flagged concerns that decisions under this section could take up to 20 years and don't clearly allow court challenge. At this point, Solicitor General Tushar Mehta said that the Act specifically provides for judicial review. Several senior advocates raised constitutional and religious freedom concerns in their arguments. Dr. Abhishek Manu Singhvi argued that the definition of collector is overly broad and the term contrivance used in the Act creates unnecessary bureaucracy. He emphasized that this case squarely falls under Articles 25 and 26, making it apt for Article 32 jurisdiction. Senior advocate C.U. Singh stressed that Article 26, unlike Article 25, protects religious and charitable institutions without requiring proof of essential religious practice, and cited precedents like Shri Hurmat to assert that the state cannot interfere in religious affairs. Senior advocate Rajiv Shakdar questioned the 5-year probationary requirement for certifying someone as Muslim under Section 3R, calling it a problematic intrusion into religious identity. Advocate Huzaifa Ahmadi added that changing the definition of Waqf and introducing a practicing Islam condition undermines religious freedom and may effectively suspend Waqf rights. Further, advocate Sanjay Hegde recalled historical struggles like the Akali Dal movement to highlight the consequences of removing community control over religious properties. Further in the hearing, Solicitor General Tushar Mehta defended the Waqf Amendment Act by stating that the central government has always had the power to nominate members to the Waqf board, even under the earlier law. On the issue of Waqf by user, he acknowledged that misuse exists, but argued that this cannot mean genuine Waqf by user does not exist. He also pointed out that Muslims today have the freedom to create trusts instead of Waqf, and cited judgments from the Hyderabad Nizam era to support the legal evolution of Waqf. He accepted that some wording in the amendment which seemed to override court orders should be ignored. Responding to concerns about older public trusts being taken over as Waqf, he said it depends on the facts and past legal judgments. He clarified that the amendment will apply to newly formed boards and not to the boards already in place. While the Chief Justice of India raised concerns about legislative overreach and retrospective invalidation of Waqf, Mehta maintained that the amendments are within constitutional limits and aimed at public interest, noting that most challenges come from individual litigants and not Waqf board themselves. Let me tell you, the court today proposed an interim order stating that properties declared as Waqf by courts, whether through Waqf by user or by deed, shall not be denotified while the matter is under hearing. It also clarified that proviso in the Amendment Act which excludes a property from being treated as Waqf during a collector's inquiry into whether it is a government land will not be given effect to for now. Additionally, the court was about to direct that all members of the Waqf boards and the Central Waqf Council must be Muslims except for the ex officio members. Like I said, the CJI was about to dictate this order, but following fervent requests by the Solicitor General and Counsel for other respondents for a hearing before the interim order, the court posted the matter tomorrow. Stay tuned for further updates on this matter, and you can also visit livelaw.in to read live reporting of this important matter directly from the court. In a significant judgment, the Supreme Court has upheld the use of Urdu on the signboard of a municipal building in Maharashtra, advocating for respect towards the country's linguistic diversity. A petition was filed challenging the Bombay High Court's decision, which had allowed the use of Urdu on signboard of the new municipal council building in Patur Akola district of Maharashtra. The petition argued that using Urdu violated the Maharashtra Local Authorities Official Languages Act 2022. However, the Supreme Court has dismissed this challenge, stating that the use of an additional language such as Urdu on the signboard was not a violation of the Act. The court emphasized that the purpose of using Urdu was for effective communication and advocated for respecting the linguistic diversity of the country. The bench of Justices Sudhanshu Dholia and K. Vinod Chandran clarified that displaying an additional language like Urdu did not violate the Maharashtra Local Authorities Act 2022, and Justice Dholia in his judgment pointed out that language should not become a cause of division among people. He addressed the misconception that Urdu is alien to India, explaining that it is an Indo-Aryan language that developed in India as a means for people from diverse cultures to communicate. The court also highlighted that Urdu has been integral to Indian culture, with its vocabulary interwoven into daily conversations in Hindi. The judgment emphasized that language is not tied to religion but is a reflection of culture and community. The court said that Urdu, known for its association with the Ganga Jamuni Tehzeeb, represents the composite cultural ethos of northern and central India. The court further referenced past rulings like Uttar Pradesh Hindi Sahitya Sammelan versus State of UP from 2014, where Urdu was declared the second official language, reaffirming the importance of preserving India's linguistic heritage. Moving ahead, the Supreme Court has set aside a Bombay High Court judgment that had refused to entertain a plea seeking possession of 2 flats unlawfully occupied by the Maharashtra Police Department since 1940, a period spanning 84 years. The case involved a writ petition filed by the appellants seeking the recovery of possession of 2 residential flats in Mumbai that were handed over to the police department in 1940 during British rule and have remained under their control since. Shockingly, the rent for these flats has remained unpaid since the year 2008. Despite these facts, the Bombay High Court had dismissed the writ petition, stating that an alternative remedy, that is filing of a civil suit, was available. But calling the High Court's decision erroneous, the top court has observed that this was a clear case where writ jurisdiction under Article 226 of the Constitution should have been exercised, instead of pushing the petitioners to file a civil suit under such an inordinate delay. A bench of Justices J.B. Pardewala and R. Madhavan emphasized that the availability of an alternative remedy is not a bar to invoking writ jurisdiction in exceptional circumstances, especially where gross injustice is apparent. The court also pointed to the historical context, noting that the flats were handed over in colonial India, possibly under pressure, and criticized the police department for continuing their occupation without legal backing or rent for nearly 2 decades. Finally, allowing the appeal, the Supreme Court directed the Deputy Commissioner of Police to file an undertaking that the department will hand over peaceful possession of the flats to the appellants within 4 months. In another important order, the Uttar Pradesh State Consumer Disputes Redressal Commission has ruled that a consumer complaint against WhatsApp is maintainable in India despite it being a foreign entity. The commission was hearing appeals filed by former IPS officer and current Azad Adhikar Sena President Amitabh Thakur, whose complaint against WhatsApp was earlier rejected by the District Commission in Lucknow. Thakur had alleged that his WhatsApp services were unnecessarily disrupted for 6 hours, affecting his work and thereby violating the platform's terms of service. He had sought compensation, but the district forum had dismissed his complaint, saying that WhatsApp is an international platform and that Thakur had not paid any money, so he could not be considered a consumer. However, the State Commission has disagreed with this, stating that WhatsApp provides services to attract users. Its fundamental purpose is to offer a platform for personal communication, making it a service provider. It operates in India and offers its services to Indian users, so it cannot escape consumer accountability merely on the ground of being a foreign company. The Commission also firmly rejected the District Forum's view that WhatsApp users are not consumers under the law. Calling that conclusion legally incorrect, the Commission directed that Thakur's complaint be registered as a consumer complaint and be disposed of within 90 days as per the Consumer Protection Act. In another update, the top court has refused to entertain the National Investigation Agency's plea seeking cancellation of bail granted to 17 Popular Front of India members in the murder case of RSS member Srinivasan in Palakkad, Kerala. The NIA had moved the apex court, claiming that the accused had violated their bail conditions, including contacting witnesses and co-accused, using multiple phone numbers and even switching off their phones. However, a bench of Justices Abhay S. Oak and Ujjal Bhuya observed that the appropriate forum to raise these allegations would be the special court or the High Court and not the Supreme Court at this stage. The top court noted that the Kerala High Court, while granting bail, had already left the door open for the NIA to seek cancellation of bail in case of violations. The court, let me tell you, clarified that if the NIA's plea for bail cancellation does not succeed before the lower courts, its legal remedies will still remain open. Meanwhile, the top court will hear the bail applications of the remaining accused who are still in custody sometime in May. And lastly, the Karnataka High Court has come down strongly on the rise of clinics run by unqualified individuals, commonly known as quacks, particularly in rural areas of the state. Justice M. Nag Prasanna directed the state government to identify and shut down such clinics, warning that they pose a serious risk to public health. The court observed that such clinics are mushrooming across remote areas where unqualified individuals pose as doctors and mislead innocent people. Calling out the government's inaction, the judge said that it was ununderstandable how the state remained in blissful ignorance about this growing menace. The court made these remarks while dismissing dismissing a petition filed by a man with only 10th standard qualification who sought permission to register his private clinic under the Karnataka Private Medical Establishments Act. The petitioner claimed to practice alternative medicine and produced a vague certificate from the Indian Board of Alternative Medicine dated 2001. However, the court found that the petitioner had no recognized medical qualification in any stream. The court also noted that he was running a one-man clinic in Mandya district and that certificate he produced lacked credibility and did not establish any legitimate medical training. Concluding that such a person cannot call himself a doctor or practice medicine, the court dismissed his petition and directed the Health and Family Welfare Department to take action and submit a report on steps taken to close similar illegal clinics.